educate students and inform students about laws within the federal, local, and state level, laws that they may not know, their rights. We also will discuss the importance and the history of Black Lives Matters, and we will highlight stories of what it is like to be a minority in America. My name is Deborah Rubillanas. I am the Student Government Association President for Houston Community College Central. We also have in the call Tree Pham, our secretary, and Elizabeth Singleton, our parliamentarian. It is with great pleasure that I present you all today's moderators for today's webinar. LaGina Harris is an entrepreneur. Her brand, LaRae Infinity, is built around uplifting and brings positive energy to marginalized people by being socially responsible. LaRae Infinity strives to always challenge the norm and bring supportive growth to the communities we work with. Under the umbrella of her brand, LaRae Infinity LLC, she is a creator, host, producer of LaRae Infinity Let's Talk podcast and founder of her newest venture in Houston, Texas, the Space, a co-worker space for women, always considering the needs of Black, Indigenous women of color. Well-versed in her professional experiences, she has successfully released the first season of her podcast and enthusiastically prepping for season 2 to begin in mid-fall 2020. LaGina is an accomplished event planner, fundraiser, and artist. Her background includes recruitment, amazing events, training facilitation, education, and hospitality. In these electric roles, she hosted pop-up art shows featuring her art and minority artists, creating positive spaces to share creative works with her community. She helped plan citywide events and training, wrote curriculums of youth development nonprofits and an institution of higher education, as well as facilitated employee and student full recruitment cycles. LaGina is committed to her philanthropic endeavors. Recently, LaGina graduated from Volunteer Houston's Leadership Corps and is active member of the Houston Community Action Council. Currently, she volunteers helping Houstonians fill out the 2020 census with COP UW Houston on the Community Engagement Committee for Whole Planet Foundation for a second term. Serves as a newly appointed board member of the Cover Girl Incorporation and is probably one of the team ladies that organizes Share the Mic Now Texas.
Hello, everybody. All of that, just to say that I'm highly involved in the community. I believe in Houston and I believe in our collaborative efforts here, and I like to talk. So there I am. Hi, everybody. So this evening, we have with us Zenobia Bivens, member in charge at Frost Brown Todd Law Firm. We also have with us Grant Scheiner, president of the Texas Criminal Defense Lawyers Association and managing attorney at Scheiner Law Group. And we also have with us Dwight McDonald, Diversity, Justice, and Inclusion Committee representative of Texas Criminal Defense Lawyers Association, as well as a professor at Texas Tech. Correct, Dwight?
That's right.
Okay, wonderful. So we're going to get started. I would like to encourage everybody that is watching to please participate in the discussion below. Write your questions. We have Tree with us again, who will be monitoring the chat rooms, and we'll break in between each discussion to answer questions from our students and our viewers. So let's get started by learning a little bit more about each of our panelists. Can we go around and have each of y'all just tell us a little bit of your background and what has brought you here tonight? Can we start with Ms. Bivens, Zenobia?
Sure. So as LaGina said earlier, I'm an attorney and the managing partner at a law firm here in Houston. And I am a trial attorney. I do both civil litigation and white collar criminal defense. So I'm in the criminal courts and the civil courts, depending on the day and the case. And as a part of my giving back to my community and a part of, what I consider tithing, I represent low-income Black men and men of color in criminal proceedings across Texas. And so I go to trial all the time. I'm dealing with issues on a day-to-day basis. More importantly, I'm the wife of a Black man. I am the mother of a Black son. And so a lot of the issues that we're going to talk about tonight and that, you know, I spend my time doing when I'm doing criminal work directly impact the people I love, you know. And additionally, I'm a history nerd. So a lot of what I'm going to be talking about tonight goes to the history of some of the laws that you hear talked about in the news, because I believe if we're going to understand systemic oppression, systemic issues, systemic racism, you have to understand history and where things came from. And I think sometimes we lose sight of that. So I'm excited to be here to share my perspective on things.
Wonderful. Thank you so much, Zenobia, and we appreciate you being here on behalf of SGA Central. Dwight, would you please let us know a little bit about you and your background?
Yes, ma'am. As LaGina told you, my name is Dwight McDonald. I live and work out in Lubbock, Texas, which is in the northern part of Texas. We're probably a lot closer to Oklahoma than we are to Houston. So I've spent my life in this part of Texas. I grew up here, was in private practice for 22 years, was a partner in McLaurin & McDonald, PC, which was, all we did was actually criminal defense work for 22 years. And then 6 years ago, I transitioned and started teaching at the Texas Tech School of Law. We have a criminal defense clinic where our students actually represent indigent people or poor people here in Lubbock. And so I supervise those students and their representation of poor people here in Lubbock, Texas. And I am involved in the community in several different ways, but my number one involvement is with my wife and my two kids, two daughters who are 26 and 21. And I'm here primarily because both of them have friends and are involved in the movement trying to push this country forward. And so they encourage me to kind of get involved in things that they think dad should be involved in.
Dwight, thank you so much. And I'm sure that your daughters are super excited that you're on this panel as much as I am. And I can't wait to hear what you have to say later. Grant, can you give us a little bit of what you are doing here and your associations?
Thank you very much. I'm really pleased to be here. Thank you for asking me. I practice criminal defense in Houston in state and federal courts. I'm also the 50th president of the Texas Criminal Defense Lawyers Association. I've made it a key platform for this year's presidency to promote social and racial justice. We've started the association's first ever diversity, justice, and inclusion program. But beyond that, I'm pushing very strongly for legislative action to level the playing field in the criminal justice system. Through my 25 years of practice, I've seen so much injustice. And moreover, I am the proud father of a biracial child whom I am raising as a single father, and I spend every day of my life trying to make the world a better and more just place. And that is what I'm dedicated to doing. I can't be happier than I am right now to be here with all of you.
All right, Grant, thank you so much for being a part of this panel as well. And all three of y'all, thank you for stepping away from your parental duties to be on this call or on this Zoom with us. So we will be talking about qualified immunity, knowing your rights with the police, and bail reform tonight, as well as a little bit of pour over into other topics that may come up. But before we get started, I do want everybody to know that is watching and that will be watching that none of the members of our panel are here in a official capacity. They are here in individual capacities, and these are in no way advice for you to follow the law. It's just insight and knowledge so that you can empower yourself to move forward as a productive citizen. So that being said, Zenobia, let's start with you and let's talk about qualified immunity and what that means and maybe a little bit of the history with it.
Yeah, so I'm going to sort of break this down into three sections. First, I'm going to talk about policing and a little bit about that history. Second, I'm going to talk about, how Section 1983 came about. Then I'm going to discuss qualified immunity. Hold on a second, please. So first, I want to talk about policing because there's been a lot of talk about defunding the police and all that but I want to talk about how policing started in the United States, and this will help inform discussions about qualified immunity. So policing really began in the United States in the 1830s. The first police station, police department was formed in Boston in 1838. And there were really two tracks of how policing started in the United States officially. In the North, you saw them building these more formalistic police stations, police departments. And this was because business people in the North wanted to basically outsource to the state the protection of their businesses. They didn't want to spend the money on it. And as you saw cities growing and urban, it costs more and more money to provide the security. Anybody's had to pay for private security for a party or a club or whatever, you know that costs money. So you had all these businesses who had political capital, had money, and they lobbied until these police stations were formed. And so in the South, it's a little bit different, or it's extremely different.
Zenobia, so before we jump into the South and what's going on there, can you kind of break down, like in really simple terms, gist of what qualified immunity exactly means?
Well, I want to, before I talk about that, I want to make sure that I feed into it a little bit.
Okay, so this is the buildup. I apologize, go ahead.
That's okay. And so in the South, you saw slavery going on, and the way that slaves were policed were through these organized groups, right? And they came together and they were like, we're going to get all these individual citizens decided they were going to get all the runaway slaves. So you saw policing come together in the North and the South in that way. And then you saw the end of slavery and Reconstruction came about. And Reconstruction, hold on.
Uh-oh.
I'm sure it's just a brief break. It sounds like a kid jumped into the background.
So you saw Reconstruction come about, COVID life, right? So we saw Reconstruction come about and the end of slavery. And so a lot of people don't know that Reconstruction was a really, really tense time between the North and the South, even after the Civil War. And so what you saw come about at that time was the Ku Klux Klan paraded around as law enforcement, right? So people thought it was the Klan, but in actuality, I mean, law enforcement, it was really people who after hours were Klan members. And the North wasn't having that during Reconstruction because they made this promise that the slaves would get to enjoy their rights and they weren't being able to. And so you saw something called the Ku Klux Klan Act come about, right? And that was the idea that anybody acting in their official capacity, these law enforcement who are really Klan members, the federal government came in and shut it down. And so right around the Reconstruction time, the Klan got shut down in some states, right? And you didn't see it reemerge till sometime later. And why this is important is that the Ku Klux Klan Act is what eventually became Section 1983. And this ties to qualified immunity as well. So Section 1983 is the idea that somebody acting under color of law who violates your rights, privileges, or immunities under federal law or under the Constitution can be held liable. And it started with the Ku Klux Klan Act. It died out because Reconstruction under the Civil War Reconstruction ended. And so you really didn't see it getting enforced. But in 1961, all of a sudden, the Warren Court, it's a court that many lawyers know about, right? It's the court that brought us Brown versus Board of Education, the decision that desegregated. They put teeth back into this Section 1983 that was meant to stop the Klan members. And it was done under Justice Earl Warren. And it was a good time. It was a shining moment for Section 1983 claims. So you could sue people acting in their official capacity. And that is a large swath of people. I mean, Section 1983 means you can sue a mayor, governors, medical board inspectors, prison guards, which is often the way that we see it. You can sue a private individual who's acting as a government official. And so people don't know a lot about Section 1983 because the claims rarely ever survive. And here's why. So after Justice Warren and the Warren Court brought us Brown versus Board, and they, made 1983 popping again, and everybody had these rights, all of a sudden they started to disappear. And this is an interesting thing to me as to how this law that was meant to protect people from, the Klan, people acting their official capacities who are abusing people, all of a sudden disappears. And you'd think that it was because legislation was passed that changed your ability to sue police officers in their, for wrongful acts. You have this great case law that comes out that basically says that, you can take a police officer, for example, to civil court, just like you would anybody else who does you wrong for violating your rights, and sue them for money damages, right? Just like if somebody comes and hits you. If a police officer hits you and it's a violation of your constitutional rights, you can sue them. And that's great. But in 1982, the US Supreme Court came up with this idea of qualified immunity. It's not a law that Congress passed, the folks that you're voting for, they didn't pass this law. It was the US Supreme Court. They created this doctrine called qualified immunity. And so we've heard it over and over and over again in the news, particularly recently with all of the, the racial spring that's going on in our country and why are police officers being held accountable for their acts. And it's a lot of times because of qualified immunity. So the textbook definition of qualified immunity is a doctrine that provides that a government official is immune from liability for violating an individual's rights under federal or constitutional law, unless the individual can show that the right in question was clearly established, right? And I want you have to show that the right was clearly established. So basically, for all these years, you have this right to sue if they do wrong by you, right? If they violate a constitutional right or federal law. And then all of a sudden, 1982, it's over, basically, under this doctrine of qualified immunity. You want me
So in 1982, qualified immunity came about, but this started as the KKK Act, and then it moved into the 1938 Act, where you could sue anybody in an official capacity for wrongdoing. And then we move into qualified immunity that was passed on not a federal level. And so at this point, basically, you have to prove that somebody, a police officer did you wrong, correct? And how do you prove that? Because I heard you say that clearly established. I mean, it's clear to me that the police officer punched me in the face. So how do I establish that that was the wrongdoing if it was the wrongdoing?
So you typically could bring a Section 1983 claim, but what qualified immunity did is it put the burden on the victim to prove that the official's defense does not apply, because qualified immunity is a defense, right? When you sue somebody in civil or criminal court, they have the right to raise defenses against you, right? They'll say, I didn't do it intentionally, it was an accident, or you wronged me first and I just responded. And typically under the law, the person who's being sued has to prove up their defense. They have to explain to the court why what they did was defendable. But qualified immunity as a defense is a little bit different, and a lot different, and that the victim has to prove that qualified immunity does not apply, right? So you have a double.
How do we do that?
How do what?
How do we prove that? It's
very difficult, right? Because the clearly established piece that you honed in on. When it comes to something being clearly established, the way that the courts interpret it is that there had to basically been some clear law or policy or something that put the police officer or whoever is at issue on notice that what they did was a violation of the federal law or your constitutional rights, right? So let me give you an example. The police were accused of stealing $225,000 while executing a search warrant. And somebody filed suit against them for stealing this $225,000, a citizen did, and the police argued qualified immunity. And the court held that they had never addressed whether the theft of property covered by the terms of a search warrant violates the Fourth Amendment of dealing with search and seizure. And they said it did not matter that virtually every human society teaches that theft generally is morally wrong. And so this is why and the reason I tied it back to the very beginning with the Klan and the Civil War is you see how you have these swings in the law, right? And things become so ridiculous that something has to be done. And I think that's what we're seeing right now with qualified immunity, right? Just as it was very clear that the Klan going after people as, and under the color of I'm a police officer, or I'm a judge, or I'm just, local, UPS person, and they're terrorizing people, the law came in and said, we got to do something. And so we have the same kind of movement going on right now with qualified immunity. How is it that somebody during issuing a search warrant, police officer executing a search warrant can steal money from you and then assert qualified immunity? So that's what you see going on. And a lot of these cases that we see in the media, people are like, why isn't anybody doing anything about the police? And it comes down to two things, right? They can either get in trouble criminally, and that would take somebody in the prosecutor side, the attorney general, the district attorney, the US attorney, to actually file charges against them. Or you have civil court, right? And in civil court, our only remedy against these officials is Section 1983. And then they assert qualified immunity, and you have to show it doesn't apply. And probably 90% of Section 1983 claims get kicked out on qualified immunity. It just doesn't happen. And so unless a prosecutor goes after them criminally, you really don't have any option. And so that's why qualified immunity is coming up so much right now. If the prosecutors don't go after the state actors, then your only way to redress your grievance is the civil courts. And that's been foreclosed in large part by qualified immunity.
Got it. So I'm going to open this question up to our entire panel, Zenobia, Dwight, Grant. What do we currently need to know about qualified immunity and how it is directly affecting people of color right now?
Well, I think part of it is, as Zenobia was talking about, it protects police officers, and you seldom, if ever, see police officers be charged criminally. And I don't know about you all, but I have two daughters. I know that Grant has a son and Zenobia has children. What happens if you don't punish your kids when they do something wrong? They will continue to do something wrong. Well, that's what happens with the police when it comes to their bad acts as far as getting a prosecutor to go after them. That seldom, if ever, happens because prosecutors are elected officials. They want to get reelected. And I don't know if you young people are old enough to remember, but there was a time 10, 15 years ago when judges, prosecutors, congressmen, senators, everybody that was running for election, their mantra or motto was tough on crime. Well, you can't be tough on crime if you're actually prosecuting the police who are supposed to be protecting people. And so it's almost impossible to get people. It's becoming easier now, but the reality is it's almost impossible to get a prosecutor to go after the police, because if the police union turns against you, now you have a real problem as far as getting reelected. So it affects the minority community in that I tell people all the time, when you see that police car go by and it says protect and serve is for the people on the other side of town. It's not for us. We get law and order. And when they say law and order, what they mean is, I'm the law, you better follow my order. And if you don't, there will be consequences. So I try to teach our kids, you need to understand who you're dealing with, and you're dealing with someone who's never had any consequences. They don't have consequences. So I can do whatever I want because criminally, I know I'm not going to get charged. And civilly, I'm going to be able to claim qualified immunity. And that qualified immunity is so strange. There have been cases where prison guards have actually beaten prisoners on tape. They had the video, but they claimed qualified immunity. And the court said, well, since this case has never come up before, they're going to be able to claim qualified immunity, and we're going to grant them qualified immunity because it's not a common occurrence. So the stranger the officer acts as far as what they do to people, the more likely it is they're going to be able to claim qualified immunity, because one of the tenets is it's never come up before. So because it's never come up before, you're granted qualified immunity. So, you know, now that Derek Chauvin has had his knee on George Floyd's neck for 8 minutes, you know, they're going to have to think of another way to treat people, because that may not be available to them as far as qualified immunity. Well, so I tell our kids, look, your best bet, you want to have as short an interaction with the police as possible. You're never going to win an argument or a physical altercation with a police officer on the side of the road. Never going to happen. So get them what they need as quickly as possible and get away from the police.
Right.
In
So,
your
Grant,
interaction with them as soon as possible.
Oh, I apologize. And you said do what?
Get away in your interaction with the police as soon as possible. Get away from them, because nothing good can come from you having an extended interaction with the police.
Got
in
it.
my
Quick
estimation.
and concise. Quick and concise with it. Grant, I see you nodding your head, very much so. So how can we, as a community, young people, women of color, men, anybody, the others, people that are not cops, how can we protect ourselves, keep it short and concise? What is another thing that we can do when we're talking about qualified immunity?
All right, so, you know, qualified immunity, there are jurisdictions across America who are trying to reduce or eliminate qualified immunity, do it legislatively. And I'll have some more to say about that under the legislative action portion of this. But, you know, this is all about police accountability. They're not being held accountable criminally because grand juries often refuse to indict police officers. When they do, juries often refuse to convict police officers. That's in state court and in federal court. And then in civil court, as Zenobia points out, oftentimes plaintiffs have no recourse. So what we're seeing now in America, it's been getting worse and worse, is that a group of people who work for the government have not been held accountable for their actions. And because of that, their actions have become progressively more brazen. The most stunning thing about George Floyd, I'm afraid to say, is not that he was murdered. We have had people of color murdered at the hands of police for many decades now. It's that these police officers did it out in the open in broad daylight with cell phone imagery running. People were recording the event and the police still didn't stop. And this seems to me, and I'm not speaking for Texas Criminal Defense Lawyers Association, just as a practitioner and a citizen, it seems to me that this is a result of not holding the police accountable. So what can we do? Well, there are a couple of things. First is for your own protection. I echo what Dwight says, which is you don't want to be the plaintiff in one of these suits or the complainant in a criminal case. You may be in the moral right, but it won't help you very much if your parents have to bury you. And I'm sorry to speak that alarmingly about it, but if you find yourself confronted by the police, be compliant. Get through the encounter. Do whatever you have to do to survive it. And then later on, you can hash things out in court. All right? It's important that you get through it intact. And then later on, if you want to get involved legislatively or make your community a better case or help hold the police accountable, then push for new laws. Join a citizen review board. Get involved. There are plenty of ways to do it. I'm not going to name, certain legislators or elected officials out there, but you probably know who they are. You probably know who's receptive to these kinds of arguments. Show up at their offices and volunteer and say, I am here to help. I promise you, they will find something for you to do.
Yeah, that sounds just about all we can do. It's a challenging thing to just, have to say, get through it. And that's why we rely on practitioners of the law, such as each of y'all. And once again, each of our panelists are here in their individual capacities, everybody. So take their advice and opinion for what it is, advice and opinions, and not official capacities. I believe Tree has questions from our SGA student body. So I'm going to bring Tree on.
Hi guys. Can you guys hear me well?
Yeah, we can hear you, True.
All right. So right here, I can see that there's no question.
We had a question about whether we were recording this, and that's a good question, actually.
That is a really good question. We are recording, and Madam President Deborah said that it will be available shortly after the panel is closed. And we are also on Facebook Live. And so I believe it will be available on your HCC circuit TVs, as well as on their Facebook channel. And you know, one thing that I always say, Grant, that I've been saying lately, especially as everything's been coming up, is thank God for cell phones and recording, because everything that's happening right now in society and in the United States is nothing new. We are 400 plus years into injustices for several different others. And now that we have cell phones, I always tell people to keep their cell phones charged and know who to hashtag and tag in social media, because we no longer have to wait for media to pick up a story. We can make the story right on our social media platforms, and it gets picked up and it trends, and then it becomes the reality of our country. And so, sir?
May I add something to that?
Absolutely.
For anybody watching this, it is legally permissible for you to video record a police encounter, whether you're involved in it or someone else is involved in it. Just make sure you do not hinder the police investigation or obstruct it in any way. Remain at a safe distance. Use the Zoom function. Microphones are good and can pick things up at a distance. So if you want to stand 10, 15 feet away, sometimes police officers will say, put that telephone away, put that phone down. You are not going to record this. You're within your rights to do that. However, remember what we said earlier, which is when it comes to a police encounter, most important thing is to survive it. So if you have a police officer who doesn't know what he's doing and attempts to take your cell phone away from you, even though you're not obstructing that police officer, you know what? Let him have it, file a complaint later on, and maybe he'll get fired for it.
Right, and we'll trust our phone when it stops recording to upload to our cloud in the sky, and we'll have it on a different logon screen until you get your phones back. So I'm gonna kick it back over to Zenobia to tie together everything we've said about qualified immunity really fast. Ms. Bivens?
And so I'll say this, that right now, a lot of people are feeling hopeful, and there's good reason, right? As I was explaining, history shows that time and time again, when we get together, you know, abolitionists and Reconstruction and emancipation brought us the KKK Act. The Civil Rights Movement and the Warren Court brought us, you know, a 1983 claim and gave it power. And this is another time where we can get together and make a change as a society about something that we don't think is right. And we've done it over and over and over again. So all this hope that we're feeling in the midst of COVID and some things that people are now seeing on video for the first time that have been going on for a long time, you should still feel hopeful, because there is a long history in this country of making change because people decided that they were going to get together and protest and tell our elected officials that it's not right. And I think the best thing that you can do, and to tack on to what Grant was saying, is in about 2 months, you have the right to vote. And there are a lot of elected positions. It'll take some time. It's annoying when I have to do it, is go through each one of those elected positions and figure out what they do. But it is very important. If you go to our courts on any given day, in Texas, we elect our judges. We elect so many different positions. If you go and see what they do, you'll understand why it's important for you to vote. And so, you know, I guess in closing, there's proof. We can do it. History shows it. We can change things.
Got it. Y'all are making this panel so easy because you're lawyers. I'm just like, yes, let's wrap it up. So we're right on time. We do have a question from our student body about George Floyd. And I'm sure a lot of us are wondering, we've heard survive. We have cell phone cameras. We have been witnesses. And the question is, in the case of George Floyd, was there absolutely nothing the citizens could have legally done to prevent his murder? And when that question's asked, the first thing that comes to mind for me is the original video that came out, and the young lady that was shooting it or recording on her phone. She talks about being helpless in the moment, and it was the only thing she could have done. I know there's a paramedic on the scene that was telling them to check his life signs and his vitals. And so there were a lot of people there that were yelling and screaming and asking for stopping. But was there anything legally past that could have been done? And let's go ahead and open up with Dwight.
Well, I don't know if there's anything legally they could have done, but the reality is you are entitled to defend yourself, or you can defend someone else. Now, the question is, you know, you see what's going on with Derek Chauvin's knee on his throat or neck, and the question is, that's an official police action. Could you possibly claim self-defense or defense of another? I don't know that would necessarily work, but I don't know that you have a right to interfere with what the police are doing, other than, you know, I mean, videotaping is not interfering. But to go back to what Grant said, they knew they were being videotaped. Derek Chauvin had his knee on that man's neck for 8 minutes, and he had his hand in his pocket like he didn't care, and it was just another day in the park. And again, I go back to, I think the reason that he did that, when people talk about what they saw or what they're thinking when they see that, when I saw that, what I'm thinking is, that's someone who has never been held accountable before, and he's not worried about being videotaped because he knew he was being videotaped. He's not worried about what he's doing to this man. It's just another walk in the park for him. But legally, could anybody do anything? I don't know that legally you'd have a right to interfere. And the other concern would be, you see what they're doing to that young man. If you interfere in that, you're probably going to get the same, if not worse.
Got it. And what, Grant or Zenobia, for this question, what is the likelihood that qualified immunity will go away?
I don't have a crystal ball, and so I can't give the over/under for qualified immunity going away. But I will say this, that there are voices politically from both sides of the spectrum who are speaking out against qualified immunity, because an important piece about what I was saying is that it's judge-created law, and you have very conservative judges even who don't think that that's right. Judges do not create law. I mean, all of us know that. Judges interpret the law. That's their function, right? And so there's voices from all across the legal community who have trouble with qualified immunity. And so, you know, the more people are educated about qualified immunity, the more they speak out about it, we have a better chance. There's, you know, so who knows? Maybe the next administration will change it.
Got it. Before we move on to our next topic, Dwight, Grant, do y'all have anything else you'd like to add to our qualified immunity talk?
I'll defer to Grant.
All
There's
right.
a reason why I had muted myself. It's because everybody else had spoken so brilliantly on it.
Yes, yes. So thank you so much, Zenobia, for leading that part and breaking down qualified immunity. Deborah, do you have a question?
Yes, Tree's trying to say something real quick.
Yeah. So there's actually the question that some students ask that I'm scared of the police. Can we wait and stop till we are in a very public place?
Okay, got it. So I don't know if everybody heard the question, but basically if you're pulled over, can you wait and stop before you pull over to have your encounter with the cops? And I've always been told that if you're uncomfortable, to put on your hazards and drive slow until you come to a stop. Where are we at with that?
Does anybody wish to venture into that? Because it's actually a complicated question. Okay, so I'm not here to dispense legal advice, but I will say this. If you have a duty to pull over as soon as you can practically do so, as soon as it's practical to do so. For those who are not sure about what to do in an encounter like this, you risk being charged with felony evading detention in a motor vehicle if you don't pull over right away. So yes, you can go slow, you can put on your hazards, but if a dashboard mounted video camera shows you driving past one parking lot and another, you're not only going to get stopped and possibly charged for whatever the original reason was for stopping you, but you could go to jail for evading detention. So I would say this: pull over as soon as you can, as soon as it's practical to do so. And in most instances, that would probably allow you to exit from the freeway and find a safe place to pull over. You're at an awful risk when you either run from the police or you give them an argument that you are running from the police. Either way, it doesn't end well for you.
And, you know, I've been pulled over by the police in East Texas, and it's dark and you're on those 2-lane high, you know, and you have to make that choice. And unfortunately right now there's no guarantee about anything, and you're taking a chance if you don't just pull over. So, you know, my dad always told us, don't drive at night in certain parts.
Very true.
Well, and I
very
think
true.
the other deal is you need to understand that if they're just pulling you over for speeding, or if they're pulling you over because your taillight's not working, and you continue to drive to a safe place, even if you put your hazards on, you run the risk of, even if you don't get charged with evading arrest in a vehicle, you run the risk of being arrested for your taillight being out or speeding or whatever, because they can actually, when you get a speeding ticket, they actually have the option to take you immediately before a judge. They can arrest you at that point. And so you need to be concerned about failing the attitude test and just having the officer, even if you're right, they have a saying, you may beat the rap, but you're not going to beat the ride, which means you may beat the charge against you, but you're going to jail today.
Got it. Graham, were you saying something?
You know, I would always trust Professor McDonald's overview of the law over mine. There was a case a few years ago. It went all the way up to the Supreme Court, called City of Lago Vista. And
Yes.
basically about the only offense that they can't haul you off to jail for is speeding. But they can, if you are speeding, figure out other things to charge you with and then haul you off to jail. I think that the problem in the Lago Vista case was they pulled a soccer mom over for speeding and hauled her off to jail. And if you want to see people get upset, it's watch what the police do to a soccer mom. That got people really interested in it. But, you know, I agree with Dwight. You know, you just, if you appear that you are fleeing from the police, look, even if they don't arrest you for something, they could mysteriously shut off their video recording equipment, and then who knows what happens. I've had a lot of cases where the video just didn't seem to be functioning properly, or the police officer's microphone cut out for some reason. Don't put yourself in that situation.
So what we're getting out of this discussion, everybody, is to survive police encounters, be mindful of what's going on, record when you can, but comply and survive the encounter and argue in court if you need to. Qualified immunity is a hot topic right now. And on both sides of the line and everything through the middle, there are judges and lawyers and people that are writing and understanding the laws. They are aware that qualified immunity is a bit of a catch-22 for your average citizen. And that question that our student body brought up is a great way to caveat into knowing your legal rights with the police. Laws are written and they're passed, and it's all about the interpretation. And so we are going to talk about knowing your rights, and Dwight's gonna kind of break down what that's about, and then we'll go into a little bit more detail.
Well, with regard to knowing your rights, the first thing you need to understand is in an encounter with law enforcement, regardless of what your rights are, in that instance, the police officer is always going to be right, and your best bet is do not get into an altercation with the police officer on the side of the road. because that's not going to end well for you. Your best bet is you can have those conversations at a later date under different circumstances, namely at court or with citizens review boards. First, right, that I think you need to understand is, and I'll put on my face mask here because I'm required to wear this at school all the time, but for those of you who can't see that, Texas Criminal Defense Lawyers Association, plead the fifth. Okay, so people seem to think, and I've represented any number of clients who have gotten themselves into a situation where they were stopped for whatever reason and decided they could talk themselves out of going to jail or talk themselves out of getting charged. In 28 years, I don't think I've ever had a client who talked him or herself out of getting charged with whatever offense the officer decided they were going to charge them with.
Wouldn't be your client though, would they?
Exactly. And the reality is, usually when they're talking to the officer, they're putting me as the defense attorney in a box because now I'm limited in what I'm able to do as far as representing you. Stop explaining. The other thing is I have people ask me all the time after they're arrested, well, they didn't read me my Miranda rights. So they should have to dismiss this. Well, Miranda only comes into effect if law enforcement is going to question you. They're allowed to ask you certain questions just to identify yourself and those types of things. But if they're going to interrogate you about the charges or the offense, then yes, they have to Mirandize you. The first question the judge is going to ask if you challenge them and say they didn't ask me or didn't Mirandize me was, are you in custody or are you not? And basically it boils down to, during this interaction with the police officer, were you free to leave or not? If you're not free to leave and they're going to continue to question you, then yes, they should read you your Miranda rights and let you know that you have the right to remain silent and that anything you say could be used against you. If you're free to leave, and trust me, every officer is going to come in and say you were free to leave. If you're free to leave, then it doesn't really apply. So you have to understand, stop. You don't have to talk to the officer. You give them your information, but as far as where you're going, what you're doing, where you're coming from, you don't have to explain any of that. Now, understand this. There's a good possibility they're going to say, well, since you're not going to cooperate, I'm going to go ahead and arrest you. Or if you're charged or they're investigating you for driving while intoxicated. Well, if you go ahead and do these field sobriety tests, or if you'll go ahead and blow into my portable breath test, I'm not going to take your driver's license. But if you don't do this, then I'm going to charge you and I'm going to take your driver's license. Well, I tell my clients it's a heck of a lot easier for me to get your driver's license back than it is for me to try to beat a DWI when you have provided the evidence against you by performing those field sobriety tests or by blowing into that breathalyzer voluntarily. Right. So
we definitely, the questions are already going off on this, and we knew this was going to happen, especially talking about police and knowing your rights. And I think this is more so a comment, but we'll go ahead and it says, why does this sound like Germany, Nazi Gestapo? Why are we afraid of our own police? This is so wrong. So I think that was more of a rhetorical question with a comment behind it. And then we have a question, what type of police reform is currently going on, especially in the case with Breonna Taylor? And we'll do that part of the question because it's a three-part question.
I'm not sure that there is. I mean, there's plenty of conversation about police reform or defunding the police, which I think is a terrible term because it becomes politicized and it gives people the right to kind of distort what that actually means. But there's plenty of conversation. I don't know that anything has been put into action yet. I know that Grant is pushing hard and legislatively to get some things changed here in Texas. but I don't really have an answer to that question. Grant or Zenobia?
And the question is about what is going on right now as far as criminal justice reform?
The question is, what type of police reform is currently going on, especially within the case of Breonna Taylor? And I know I was listening to NPR today, and they were talking about a settlement of multi-millions of dollars for Breonna Taylor's mother, as well as some firing and everything else. So I know currently that's what's on the table, but that is the question.
And can I say this? I think a lot of people are mistaken in thinking that criminal justice reform is something new. I mean, there have been a lot of people who've been working on it for a long, long time in communities of color. I mean, there used to be juvenile life without parole. I mean, they used to send kids under 18 to prison for life with no parole. And so, you know, there's a lot of people who've been working on that. The decriminalization of marijuana is a long time thing that has been going on and is starting to hit strides. And so I don't want to be the Pollyanna, but I do want to remind people that, you know, like Grant said, you just saw the video. But before that, there were people who were representing families who were making these claims previously, right? And defending people who've been treated like this for a long time. And so there are ongoing strides to change things. And, you know, you're hearing about Breonna Taylor and George Floyd because there's this movement going on now in our country, but it has been going on for a long time. And so there's ongoing movements to decriminalize, for example, marijuana, which is a huge reason that Black people and people of color go to prison. You know, that's something that's been going on for a long time.
And just to clarify, the settlement that is on the table and that was announced in Louisville is for $12 million to the family of Breonna Taylor. Clearly for a 26-year-old woman, that doesn't replace her life, but it's a start. Grant, do you have anything you wanted to add?
Sure, just very briefly. I'll, in my part of the talk, I'll come up with some legislative issues. But Zenobia raised a very interesting issue about marijuana legalization and why do people of color end up in prison over marijuana violations. A dime bag of marijuana in and of itself is not what gets a person sent to prison. The problem is that all of the case law interpreting search and seizure, if the police smell the odor of marijuana, that gives them probable cause to search. So if, let's say, a person has other contraband or has done something else illegal, and the only thing the police have is what they claim is an odor of marijuana, because of that case law that says the police have probable cause, then guess what? The police can begin tearing your car apart and then looking for something illegal. And so marijuana legalization, whether you use marijuana or not, is probably an important topic because it's a privacy right that you have not to be messed with by the police. And the marijuana laws basically swallow all of your privacy laws. So there are a lot of things we're going to be pushing for, but Zenobia hits the nail squarely on the head that we've been doing this for a long time, years, decades. We've been trying to push for reform, but things do happen. They don't happen right away, but they do happen. Every Texas criminal practitioner can tell you about the time not too long ago where defense attorneys didn't even get copies of police reports. In a state Texas case, that is mind-blowing to people. And we're talking about, what, maybe 5-6 years ago, they changed that law. It used to be that you could go to some jurisdiction, some small jurisdiction, and the prosecutor could tell you as the defense lawyer, yeah, you're not going to get a copy of the police report. I'll be happy to summarize what it says for you. And then if you want to go to trial, that'll be up to you to roll the dice. Well, it took a guy named Morton to go to prison for 25 years for a crime he didn't commit. And one of the major reasons why that happened is because all of the evidence that would have helped him was contained in discovery material that the prosecutors failed to turn over. So we now have Texas discovery law that allows us to get copies of police reports. So we're not completely in the dark. And that would not have happened but for the fact that we went to the legislature year after year after year and kept trying. And that's what we're going to continue to do. We're going to keep trying.
Can I give another example?
Oh yeah, absolutely.
Another thing that was becoming popular and now has died out is this idea of police dog lineups, dog sniff lineups, which is
Our
crazy.
panelists are all just like, okay.
You know, I had a client that was accused of arson and killing people because they took a gasoline can from the burnt, charred house and had the dog sniff the charred gasoline can, and then whichever suspect that he barked in front of was the criminal. That is how he ended up going to jail, because a dog had identified him.
Is he,
It's
is
kind
he
of
in
it's kind of
jail,
tough
or
to
is he
cross-examine a dog.
Yeah, dogs are really difficult. They don't take their oath seriously when they come to court.
No, I know a few.
Wow. And you know, Grant and Zenobia, to touch on something you said, I know California right now, because of the legalization of marijuana, is having a lot of pushback with people that are currently serving time for marijuana possession, even down to dime bags. Now, a lot of white Americans are in California being very prosperous on the cannabis plant. And there are a couple of businesses that have made oaths to hire past offenders, which I don't like that phrasing, because what were you you know, what'd you do? Once they get out of jail for being a criminal or federally locked up. So we have a lot of work to do, but as you said, Grant, we are doing the work, and it moves slowly. And as you said, Zenobia and Dwight, it's important to go out and vote. And you have the opportunity and the right to go out and vote. I know that HCC Central, as well as the other campuses, SGA, has voting polls and sites that I'm sure they're going to be posting in the next couple of months. It's important for us to fill out the census. Houston is under our target right now for filling out the census. The 2020 census is due on September 30th. All you have to do is go online, and literally I was surprised because of how quick it is. It's like click, 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 and it, go ahead, Dwight.
If I could,
Absolutely.
join in your encouraging folks to complete the census. I am the chairperson for the Census Committee for Lubbock County, and it is important that you complete the census, because billions of dollars of federal funds are extended based on your census and population. In Lubbock County, it's worth about $1,500 per person that responds to the census per year for 10 years. So each person that responds in Lubbock County, we get back $15,000 over the 10 years in federal funds and grants. It also helps to determine those boundaries that we use to vote for legislators. And to be quite honest, in this part of Texas, we didn't have people that, well, in Texas in general, we weren't all that interested in counting everyone, because the powers that be understand that if everybody gets counted, that may change some of the districts, which may not give them the power that they have currently. But what changed that in the last 2 weeks is Texas was actually slated to pick up 3 spots in the U.S. House of Representatives based on census projections. Obviously, COVID has had an effect on that, but the state has not spent money to try and encourage people to respond to the census. California was scheduled to lose 2. New York was scheduled to lose 1, so we were going to pick up 3. Now with the projections, it looks like Texas will have a difficult time maintaining the representatives that we have, and we may actually lose 1. And that 1 may be the guy who represents the district that I live in. So he was all about having a press conference last week to encourage people to respond to the census. So
Absolutely.
Please, it takes you 5 minutes. If you go to uscensus2020.gov, you can fill that out. And even if you're a college student, you need to respond to the census based on where you would have been on April the 1st. So if you are not from Houston and you are attending HCC and you would have been there on April the 1st, if we hadn't had the pandemic, then you need to respond to the census and include your residents being in Houston at that point, or wherever you're going to school. That's where you should respond. And if your parents have already responded and included you, that's fine. The census has a way to capture that conflict and sort out where you should be placed.
Absolutely.
I apologize for the advertisement.
No, it's not an advertisement. It needs to be said, and this is what this whole panel is about, is bringing awareness to our laws, and the census directly affects our laws and our seats for the people that make our laws and dictate or over our laws. And just to reiterate what Dwight said, $1,500 pretty much per household is lost for each person that does not fill out the census within your community. So a quick way to give back to your community is to fill out the census. 5 minutes, everybody. And so back to questions from our HCC student body. Do you believe a third party should be issued to do initial investigations for policing instead of investigating within themselves? Let's start with you, Dwight.
I think that we should have citizens review boards or outside forces. You hear people talk about the thin blue line all the time and how police officers, and I was on a panel several months ago talking about policing with the police chief here in Lubbock, and he was explaining to the folks on Zoom that, we have a lot of good police officers. It's just those few bad. And my response to him was, well, I guess it depends on what your definition of good is. Because the reality is the bad actors are being protected by the quote unquote good police officers, because they know who the bad actors are and they never do anything or say anything about them. So I guess it depends on what your definition of good is. By the same token, when those folks get in trouble and you file a complaint, officers are reviewing other officers, and seldom, if ever, do they hold those officers accountable, because you want to stay a part of the thin blue line. You want to stay a part of the group. So I think that it is a much better idea to have outside review folks take a look at what officers have done, especially now that everybody has a cell phone and everybody's videotaping this stuff. It's a heck of a lot easier than just relying on what the officer said. Whereas we had to do that in years past. Now I can see for myself, that's just not right.
Right. Zenobia, would you like to touch a little bit on third parties, internal versus external investigating?
Yeah, and so I have a colleague who just went, he's in Ohio, who just left our firm to go head up a citizens review board. And so I looked into a little bit more, but I think that it's good in general, because a lot of police departments are like corporations, right? Corporations bring in consultants all the time. Corporations that, require less money to operate than a police department. I mean, we're talking about millions and millions and billions of dollars in our country spent on policing. Why wouldn't you have a consultant or an outside party come in and identify the problems that you have? Because to be honest, we can talk about it just police, but in all corporate or large system environments, people don't blow the whistle. They let it go on and on and on. It's almost like the whole idea of don't snitch. We call it the thin blue line when it's the police, but that's something that people are not inclined to do. And so if you're doing it in corporate America to improve profits and improve systems and outcomes, why wouldn't you have an outside party come in or a committee or whatever to review what's going on in a police department? So I'm all for that. Why not do it?
Right. Grant, did you have anything you'd like to add?
Only that I agree with everything that's said. I favor a multi-pronged approach. I think that when there is an incident, it should be reviewed internally by the police. The Internal Affairs Division sometimes is set up to be almost an adversarial division within the police department, and they do find some things that are very helpful to an investigation. You can also have an outside agency. Many of us on this watching today are probably too young to remember the Rodney King case. The Rodney King case was prosecuted in state court. It reached one result, and then it was prosecuted in federal court for a federal civil rights violation. So an outside prosecution agency got hold of it and was able to make some headway. And then finally, lawyers can do investigations. Like Zenobia, for example. I've seen some of the work that she does, and it's every bit as good and probably better than many police agencies can do from an investigative standpoint. I watched the case she did, and I'm going to embarrass Zenobia by saying it was the best trial work I had ever seen in my career. So yeah, I think it can be, these incidents can and should be investigated and prosecuted multiple ways, because the more spotlights you shine on something, the more likely you are to illuminate it.
Well, I like that. I like that. Well, let's illuminate, y'all. Dwight, I'm going to have you wrap up with just a quick question about knowing your rights. What do we need to know right now about our rights, that immediately walking around with everything going on, Breonna Taylor, George Floyd, Vanessa right here from Houston, Texas, disappeared on a base. What do we need to know about our rights, and when we're talking about police, and how do we navigate that?
Well, I think that number one, if you have the ability, you need to turn on your phone or recorder when you have an interaction with law enforcement, and it's probably not a bad idea to let them know I'm recording this. But you need to actually make sure that your recording is going straight to the cloud, because there are some officers who will snatch your phone and turn it off, or they will throw. I've actually had a case where an officer grabbed a phone and just threw it up against the wall. So yes, they will do that, but that's one way of protecting yourself. And like Grant was talking about earlier, all these officers are supposed to have video and microphones going anytime they have an interaction. But you would be surprised at the number of times that doesn't actually work. So start off by letting them know that you're recording. The other thing is comply. Get this done as quickly as possible. And if they have it in their mind that you're going to go to jail, you're not going to talk them out of it. You're not going to, what you're doing, for instance, you get stopped for a DWI, you get stopped for possession of marijuana, they're going to charge you with, in Lubbock, on one side of town in particular, we see people that get arrested for walking in the street when a sidewalk is available. And the whole purpose behind that is they want to search that individual. So if you walk out into the street, guess what? Now you've committed an offense. So now I get to talk to you and pat you down for officer safety. Really, I'm patting you down to see what you have on you. So when you have these interactions, try and make them as brief as possible. Be respectful, comply. If they're wrong, you can redress that at a later date and time in a situation where you are not putting your life at risk, because nobody wants to be a martyr. Your family doesn't want it. You don't want it. Whether the officer's right or wrong, you want to survive that interaction with that officer. So comply, even though you haven't done anything wrong or you don't think that the officer is right. You're not going to win that on the side of the road. So comply with the officer, do what they're asking you to do, get that interaction over as soon as possible. If they have decided to arrest you, do not resist, because you may get charged with a Class C misdemeanor, and then by resisting, you elevate the charges, which means that now you have created a much more serious problem than you had before. So do what is required to get that interaction over with as soon as possible.
Okay, thank you. So before we move on to bail reform, we have one more question. I'm going to kind of sum it up. And if, let's see, if Grant, maybe in like 30 seconds, you could give me a quick answer on this, and it will caveat into bail reform. And this question is it's a two-part question, but it's pretty much about evaluations. And as attorneys, do you have a particular evaluation you can request to be taken for police officers in cases of police brutality? Is there an evaluation? And the first question is, what type of mental evaluation? So we're talking about evaluations of mental health when it comes to police brutality cases.
So is the question geared at how we evaluate police officers?
So the two-part question, the first part is, I think it's not something that we can actually answer because you're not a police officer, but you may have some insight in this. It's asking what type of mental evaluations police officers go through to be deemed fit for duty. And then the second part is, as an attorney, do you request any of this type of stuff when it comes to police brutality cases?
That's actually a pretty good question.
It is a very good question.
Yeah, because they're supposed to undergo psychological evaluation, and it's a a continuing thing when there have been traumatic incidents that police officers have had to deal with. I can tell you on the criminal defense side, we generally don't get our hands on those kinds of things because first of all, there's something called the HIPAA law, which basically protects the privacy rights of individuals in their medical and mental health records. Now, you can, as a practitioner, try to subpoena that material and have it brought to court, but it's likely that some lawyer on the other side, either a prosecutor or a police officer's union lawyer, will try to quash your subpoena, and then it will go before a judge, sometimes a judge who was run on the mantra, as Dwight put it, of law and order, to determine whether or not you're going to get your hands on that material. That's real hard to get your hands on the material. But I will tell you, Zenobia, I'd be interested to hear your take on this. Do you get stuff like that from rogue police officers?
I never have. I've never gotten that.
Something to think about.
It's a really good question. Go ahead, Zenobia.
Yeah, I mean, but then you're also assuming that they did go through that. Because, police training varies from state to state, to department to department. One of my Uber drivers once he was getting ready for finishing his master's degree in criminal justice to go be a police officer, I think a sheriff in Bexar County. And so he talked about all these different things that he'd done, but he was the first person I'd ever met who was a police officer who was getting a master's degree in criminal justice. And he talked about some of the training he had to do. That sometimes it depends on the department is the punchline, right? It might not even be available to you. They may not have had to go through that, right? Because I've said in other podcasts, police officers are not social workers. They are not psychologists. They're not educators. And so a lot of times the expectation for them to do all that is a bit too high. And so maybe that is part of the criminal justice reform, is to do more psychological evaluations of police officers. And then you start getting the politicians arguing about the cost of that, right? And taxpayers saying, we want to raise my taxes so that they can go through all these psychological evaluations. So the punchline is, I don't know. I think it's a great thing that they should do it, and that if we did get our hands on it, that would be pretty significant.
Game changing?
I don't know if it'd be game changing. I actually think it would. I don't want to go down this road too much, but I think it'd be a battle of the experts, because just because somebody tests a certain way, because if on one day, does that mean that their conduct is reflective of that testing months or years ago? People change. And so then you have the cost of having an expert come in, and the other side's going to have an expert. And so is whether somebody committed police brutality going to come down to two experts, evaluation of the psych report?
Got it. So we have talked about qualified immunity. So I am a citizen and I get punched in the face by an officer. And then we have talked about me knowing my rights, and I know I need to survive. My homegirl was with me. She reported it. We survived the encounter. I happened not to get arrested.
One other thing on your rights, please do not agree to a search of your vehicle or home or anything else Whether you have anything or not, the answer is always no, you may not search my vehicle. You may not search my home. You may not search my purse. The answer is always no, because even if the officer's done something wrong, if you say yes, that kind of does away with his wrongdoing. So always the answer is no.
No. So go ahead, Zenobia.
I do want to say one thing, because I had a client that almost got in trouble because of this. The right to remain silent, like that is so important. Don't say anything. And people do not think this is real. If you end up in jail, do not talk on the telephone to your mom, your dad, your cousin, your friend, only your attorney, because those jailhouse tapes come back to haunt the defense attorneys. The prosecutors pull them out and they're like, they'll figure out some way that you admitted what you did. And so it's almost like a gotcha, because you're in the jail, you want help, you're traumatized, and you pick up the phone to call your mom, and that recording comes on and it says, please be aware that you're being recorded, and you're not hearing that. So if I can just say one person from that situation, your rights extend to, you're being listened to when you're in jail. People are listening to your conversations, but most importantly, on the jailhouse phones, they're recording them, and it will become evidence against you. So speaking to rights.
Yes, so that part of TV is true. So my homegirl is recording, I'm good. The officer asks to search my vehicle. No, thank you. My homegirl is still recording. Do I have anything to say? No. Let's say I do get arrested. I'm arrested, and now we need to move into bail reform. I have not called anybody. I called my attorney, Gotcha, from gotcha.com, and I got a great non-binary attorney, and Grant is going to explain to us what happens to me next.
Okay, so I guess this is the cue to speak about the bail system. All right, so we're speaking now of Harris County. Harris County is not like every other jurisdiction, but it's fairly common, which is this. When you get arrested in Harris County, you're taken before a magistrate. A magistrate is not the judge of the court that will hear your case, but a judge who does probable cause. Usually the judge, after listening to a prosecutor's rendition of the facts as told by the police officer, finds probable cause and then sets a bail amount. And then you have a choice. How are you going to get out of jail? There are several options. Option number one is to put up a cash amount, the entire amount of bail, have a friend or a relative give that amount of cash to the local sheriff's department, and then 8 hours later, they give you the person. So if the bond is set at $5,000, your relative will have, your friend will have to go down there with $5,000 cash and give it to the sheriff. Option two is you can go to a bail bondsman. A bail bondsman will typically charge 10 to 20% of the face amount of the bond. 10% of $5,000 is $500. So your friend pays $500. That sounds like a better deal, except one, while you're out on bail, you have to keep reporting to your bail bondsman. And if you disappear or forget to report to him, the bail bondsman can withdraw from the bond and then get you thrown back in jail. Problem number two, with a cash bond, you get all the money back at the end of the case. But with a bail bondsman, that $500, that's lost forever. You may as well have burned it in the street. That's a really bad high interest loan that you're paying for. Another option is to ask for a pretrial release. So some jurisdictions call it release on your own recognizance, where you pay nothing or maybe a tiny fee for processing so that you can be let out. And then if you don't show up for court, then they come looking for you, or then they, revoke the amount of the bond, and that's how much you owe. So here's the problem with all of this. Almost without exception, it favors wealthy people, because wealthy people have quicker access to money and usually access to more money. And people of color traditionally don't have as much money that they can lay their hands on as white people. So what happens is people of color and poor people get hung up in the system. Sometimes it takes them a while to scrape together the money. Sometimes they can't scrape together the money at all, and they're trapped in jail. And unless the person wants to stay in jail and maybe lose his job, he looks for a way out. And the quickest and easiest way out, especially in Harris County, is you're brought over to court, you get a court-appointed lawyer cuts a quick deal, and you take some kind of credit for time served. Out you go. Yes, you get to keep your job, but now you have a conviction that's stuck to your record, usually for life. And that makes it harder to get other jobs down the line, or to go to graduate school, or to live in a nice condo complex. They'll run a background check on you. So the cash bail system has been a real problem all over America. In 2011, a local law firm, it's national in scope, called Sussman and Godfrey, brought a lawsuit against Harris County for its cash bail practices. And they said, what you're doing with requiring poor people to try to, get out of jail based on cash, that violates the Constitution. It violates due process of law, and it violates people's equal protection under the law, because you have one kind of group that's treated one way under the system and another group of people that's treated a different way. Well, Harris County at the time, because of who was in charge, our district attorney, our judges, our commissioners court, were dominated by one political party, decided that they would fight this lawsuit. And they went out and they hired outside counsel. Harris County spent $9 million fighting this lawsuit. $9 million is a lot of taxpayer money. And
Grant, can you repeat that again? You said that Harris County spent $9 million to defend having
to keep the unconstitutional bail system. Now, it was only challenged for misdemeanor cases. So these are crimes which are punishable by fines of up to $4,000 and up to a year in jail, maximum. For cases that involve a prison sentence, those are felonies, and they still have the felony cash bail system. But the plaintiffs in the case decided that they were going to challenge it in federal court. And, they did it on the basis of, one person had like a $2,500 bond for driving on an expired license and he couldn't afford to get out. These were petty crimes that people couldn't afford to get out in jail, and they ended up, in some instances, jeopardizing their jobs and so forth. So Harris County decided it liked to keep its cash bail system. It liked the system. It had developed it over a period of decades. So they went out and they hired outside counsel and spent $9 million and kept losing over and over again. They kept losing, and every time they lost, the Harris County Commissioners Court would dump more money into appeals and trying to defend that system. Well, there was a political sweep in Harris County, I guess in 2018. New group of people came in and said, you know what? I don't think we should defend this unconstitutional bail system anymore. And they withdrew, from defending the suit. So as a result of that, the federal court judge, Lee Rosenthal, ruled in favor of the plaintiffs to strike down the cash bail system in Harris County. They reached a settlement agreement in 2019, and the settlement was put into effect in 2020. Here are some of the things that the lawsuit was able to accomplish. One, most misdemeanor arrestees were released on their own recognizance, so they didn't have to put up cash bail. Second, many of those people now had access to public defenders, not just when they were charged in court, but even before the magistrate, when the determination was for probable cause. Until that point, there were no defense attorneys to say, excuse me, judge, what the prosecutor is saying can't possibly be true. There's no probable cause. You should let this person go. And as soon as public defenders got involved this way, cases started getting thrown out left and right. Go figure. The lawsuit also provided for text message reminders to people to show up for court, because it turns out that the reason why people show up or don't show up for court, they've studied the topic, has less to do with whether they put up cash money and more to do with whether somebody reminds them about their court date. It's as simple as that. And then finally, very importantly, they appointed independent federal monitors to take a look at the system, the new system without the cash bail and the misdemeanor cases, and see whether it was working. And it just so happens that several weeks ago, they came out with the first federal report from the independent monitors, and they concluded that the new system did two things. One, it let more people out of jail, and two, it did so without any increased risk of reoffending. So the community was not made less safe. It doesn't matter what the district attorney argued. It doesn't matter what the police agencies argued. Those, it turns out, are probably just scare tactics. Letting people out on their own recognizance and reminding them to come to court did not make the community any less safe. So where do we go from here? Those in favor of bail reform are hoping that this will spread across the country. And here in Harris County, the next step is to begin challenging the felony system. So that's where we are, and that's where we may go.
Wow. So this started in 2011, and then we got a little progress in 2019. And do you feel like because of the global pandemic, has bail reform been pushed forward, especially here in Harris County?
What a great question that is. No one's ever asked me that question, and that's a key question because it had a couple of effects. First, when the pandemic began, there was this crush to try to let people out of jail because it turns out that jails, go figure, are super spreader events. In the Chicago jail, I can't remember, Cook County Jail became one of the biggest concentrations of COVID in North America. Down in Corpus Christi, one wing of a jail tested 90% positive for COVID. And because it's the government, I guess, my understanding is that they decided not to test the rest of the jail because why would you want to do something like that? So there was this move to try to get people out of jail, but then there was an opposite move from the governor's office. Governor Greg Abbott signed an executive order, GA 13. And what it did is it suspended many rights under the criminal justice system, including those enunciated in the Code of Criminal Procedure. And it said that certain people who had crimes of violence, and they just defined crimes of violence a lot of different ways, who were either charged this way or had been arrested for that kind of behavior in the past, would be ineligible for this pretrial release. So now you had a lot of people who are being hung up in jail, and that's being litigated in court as well. So it's kind of happening in two different directions. There is a push to get people out of jail because of the pandemic, and then there's another push to keep people in jail because of the pandemic. So a terrific question, and it's anyone's guess where it goes from here. One way that a clever judge can address the issue is say, okay, I won't let him out on his own recognizance. I'll set his bond at $1. And, you know, just kind of, there's his bond. It's set at $1. He's not letting out on recognizance. But the sad truth is that many judges are uncomfortable making a stand like that because there are still a lot of people who respond to the law and order judicial candidate rather than one who says, I'm just here to protect public safety from COVID and to protect the Constitution. Hard to fit that on a bumper sticker, I guess.
It's a lot to fit on a bumper sticker, but it's a reality and it's real. I am an open watcher of a lot of law shows, and it may be because, you know, one of my family members practices law, and I'm like, that's probably what she does every day. But I've found out that lawyers don't necessarily like watching the same shows I do. But I do want to hear from Zenobia and Dwight about bail reform and your take on it, and your thoughts on where we're going and moving forward with bail reform. If we could start with Zenobia, that would be great.
Yeah, I mean, again, I think I said, oh, is it okay?
We got you.
Yeah, we're here.
Good. I think I said this in the beginning. I'm a child of history. I love to read history and understand things. But a lot of the issues with this, the bail reform is we've already been here before. Like, we got rid of debtors' prisons years ago, right? And people forget these things, right? People do not go to prison because they owe somebody $100,000 on their credit card, right? So we are back here again having these same fundamental discussions about things that our country constitutionally, legally has gotten rid of. And people have put us back here by trying to do things the easy way, and I think forgetting what the laws are meant to do, right? And so to Grant's point about why bail reform is important, I think an example is needed, right? The person that Sussman Godfrey was representing, I think, who was the exemplar for why this is important, was a woman who had children, a job, and she got a ticket for having an expired license. And basically, I think that, Grant, you probably have to correct me on this, but she may have missed a court date.
Yeah, there were three plaintiffs. One had that, another one had like a petty shoplifting. Yeah, oh, go ahead, you're doing great. Let me stay out of your way.
I don't remember exactly the facts, but the point is she had an expired driver's license, ended up with a warrant and going to jail. Her children, she couldn't take care of her children. She lost her job. She's in jail. She doesn't have money to get out because her bail is set so high, you know? And so for a expired driver's license, all of these things have happened in her life. And so, you know, she was one of the poster people for this change in the law, because that's not what our laws are meant for, right? That's not what bail is meant for. It's not to create a debtor's prison and put people in a situation that has long-term impacts for a $20 license renewal.
Right, right. Dwight, did you have anything you'd like to add about bail reform?
Well, I think that, like Grant said, a lot of times they use this to coerce people into pleading guilty, even in instances where someone hasn't committed the crime. I mean, possession of marijuana is one of the examples I like to use. We've got a situation now where, because the law changed, prosecutors may or may not be able to prove a marijuana case, because now they not only have to prove that it was marijuana, but they have to prove that it has a certain amount of THC in it. And there may only be 1 or 2 labs in the whole state that actually can test for that. Well, here in Lubbock, we're still arresting and charging people with possession of marijuana. And they sit in jail. We just, in the clinic, we just had someone who pled guilty to a possession of marijuana 2 weeks ago. Why? Because his bond was $1,500. He couldn't come up with the money to get out, and the prosecutor knew it. And so we were trying to work with him to try to find family members or whoever else to get his bond together. We actually filed a writ trying to get his bond reduced, and the judge was like, $1,500 is reasonable. So the prosecutor made an offer of time served. This person took it. Why? Because you mean if I take this today, I get out? Yeah, but we can beat them at trial. They're never going to try this case. We asked for a speedy trial. They're never going to try this case because they know they can't prove it.
Right. Dwight, can you elaborate on what time served means? So I'm in jail. I plead out, time served, so I'm free. What does that mean?
Time served means however long you've been in jail. For instance, this person had been in jail about 22 days. Guess what? We'll plead you guilty for the 22 days that you've been in jail. So you don't have to do any more jail time. You get credit for the 22 days that you were there, and you get to get out of jail today if you accept this plea. Now you have a conviction on your record for life.
Your life.
And the problem with that, and it's a situation where the prosecutors know that they can't prove that case. And rather than do what that sign that they all swear means something, which is their duty is not to seek convictions, but to seek justice, rather than do that, they will have someone plead guilty to something that they know they can't prove because they know that person wants to get out of jail. And it's all because in a nonviolent offender, we have a bond that this person can't make.
Right. So hypothetically, I'm sitting in jail, whatever they're saying I did, I didn't do. I'm a single mom, I'm a student, I'm missing work. My father is watching my children, and I'm sitting in jail because we can't come up with the 10 to 20% that my bond says that I need. And so in lieu of that, I'm like, fine, get me out of jail, whatever. And I plead, I have something now on my record forever. And so it's like a catch-22.
Exactly. And the prosecutors know that, and they don't care. And the reality is, yes, you're getting out of jail, but now you have a record for the rest of your life. The other thing is, we have a lot of people who have
Might affect your
issues,
voting
mental
rights.
health issues, and others. And if you are on any type of federal assistance, if you are incarcerated more than 30 days, you run the risk of losing that federal assistance and having to reapply to TANF or to SNAP or any of that stuff. So if I'm pushing up on those 30 days, I've got to get out of jail or I'm going to lose my benefits, which help me take care of myself and my family. So I don't want to hear about you can beat them at trial and you're talking about a trial in 2 months. I need to be home now.
And I believe Grant said that it affects voting rights as well.
Depending on the type of case.
Depending on, yeah.
Yeah.
Zenobia, you had a.
Yeah, so that applies to Section 8, right? Also.
Yes, yes.
And so let me give like maybe a different example, particularly since we're talking to college students, right? So let's, I'm going to imagine that you see the police on campus. This is a thing that people always forget about. Police on campus are police. Just because they're on a high school or a middle school or a college campus, they still do the same thing that the police riding through neighborhoods do, right? And so you get arrested on campus, 17-year-old on a high school campus, a college student on a college campus, and you go and you're already into the system, right? And so what Grant's talking about with bail, it's like, okay, either my family has to come up with this money, right? It could be 5,000, 10,000, whatever it is, or I have to stay in jail, or I can just plead out and go, right? And I can be back in class on Monday. I can help give people rides, whatever you have to do in your family, you can get back to it. But there's significant long-term consequences. But on the other end of that, let's say that you decide to pay the bail and you get out, right? There's still long-term consequences because you have to go to court every month and check in. And chances are that first time you check in, they're not going to be like, okay, we're ready for a plea deal. Oh, we're ready to take your case to trial. It could be a year, 2 years, 3 years. Every month you have to go back to court. And let's imagine you're from Houston and you decide to go to Dallas County, right? And you get arrested there and your case is pending in Dallas County. Every month you have to take off from work and go to Dallas County, right? So it's really, like LaGina said, it's a gotcha situation. You plead guilty, you get out, you have a record. You pay the bail, it could be years, 2 years, 3 years before you go to court and have a trial. And every month you're having to drive to Dallas County for your court date. So this is
And
really
one other thing, since we're talking to young people here, an audience made up of primarily college students, you need to understand this. If you get convicted of a possession of marijuana, guess what you're not eligible for? We talked about people losing Section 8 and we talked about them losing TANF or SNAP. You're not eligible for any kind of federal student aid. So it could have a devastating effect on you as a college student to be convicted of possession of marijuana, because now you got to go it alone and pay for school by yourself. You get no governmental, you don't get any help from the government. So it is a big deal, even though possession of marijuana really shouldn't be. They can use that because of the bail situation or any other misdemeanor. They use that, and it works in felonies as well. People get charged with felonies. The bond is so high they can't get out, and people will plead guilty to something that they may not have done, or the prosecutor may not be able to prove it. But in order to get out of jail, I will take this deal. And a lot of times they'll offer people probation or deferred adjudications on felonies. And, hey, if you complete this probation on a deferred, it's never going to be on your record. It'll get dismissed. Well, the reality is, very few people can complete an actual probation. I mean, it's difficult.
But that also doesn't get rid of the arrest record, because as we all know, job applications ask about arrests and convictions. So, it's a huge issue.
So I'm reading, we have a question on the floor, and Grant, thank you so much for answering that in our chat box. The question is around your felony. So I pleaded out, I have a felony. It's an election year. for our presidential election, because we have elections all the time locally that very much so matter. If you want to know more about that, go check out my podcast. Zenobia actually talks about why it's important to elect judges on a local and federal level. But I have a felony, can I vote? Grant, since you answered it, would you like to go ahead and reiterate what you wrote?
Sure. In Texas, if you have a final felony conviction, you cannot vote while the sentence is being carried out. So if you're sent to prison and you go to prison for 3 years, you cannot vote during that 3 years. If after 3 years you're paroled, my understanding is you can't vote while you're on parole. When everything has finally expired, then you're eligible to have your voting right restored.
Right. Dwight, do you have anything to add to that?
No, ma'am, I think we've covered it.
I think we have. I think that we have collectively done a great job covering some really pertinent information about qualified immunity, knowing your legal rights, and bail reform. Before we get off, I would like for each of y'all to just give what you want our audience, our HCC students, what's the takeaway? What's the takeaway? How do we move forward? What do you want them to know in a really quick 30 seconds? Let's start with Dwight.
What you need to understand is not every policeman is your friend. If you have an interaction with them, you need to comply, do whatever you need to do in order to get away from that situation and be able to live to tomorrow. As my granddad used to say, it's a heck of a lot better for him to say, there he went, than there he lays. So do whatever you need to do to avoid increasing any kind of animosity or situation with the police. Even if you think that you're right and the police officer's wrong, in that situation, out on the highway or out on the street, you're not going to win that argument. You're not going to win that scuffle. So comply, fight with them later in court where you and your attorney would have the advantage.
Got it. Grant, how about you? What is your takeaway you'd like to share with the students?
My takeaway from this is that there are good and smart people who are out there fighting for your rights, but we can't do it alone. We need your help. We need you to be active in your communities. And when it comes to voting, here is what you should do. It's not enough for you to vote. You should find 2 other people who are eligible to vote and make it your responsibility for those people to get to the voting place. Call them up afterwards, say, have you voted? Because I'm responsible for you. And then challenge those 2 people to find 2 different people to do the same, and the same, and the same, and the same. You should vote, get 2 friends to vote, make sure that they vote, and challenge each one of those people to do the same with their 2 friends. If you do that, then we will have even more good and smart people who will be fighting for your rights, and sooner or later, we will win this war.
Got it. So be cautious, survive your encounters with police, and let your legal professionals and practitioners fight your battles in court. Vote, vote, vote. Use it as a challenge. We are a competitive generation of X, Y, and Zers. So bring somebody to the polls with you. Use your voice. And Zenobia, what would you like for your takeaway to our HCC students and viewers to know?
Yeah, I think the most important thing that I want to share with everybody is that we have one of the best criminal justice systems, if not the best. No, we're gonna. Oh. That's who I'm fighting for. And
yes.
Yes. So he's excited to talk to mommy. But so what I would say is that we have, if not the best, one of the best criminal justice systems in the world. And we are all here, pointing out things that we need to do better, but do not forget that. And our criminal justice system has come through for us many times, and I've been there. When juries get together, which is a powerful tool that we have in our country that other countries don't have, get our clients to the jury and let the community decide what is justice, right? The judge in criminal cases, most of the times they don't decide justice. The prosecutor doesn't, we do. So stay informed and believe in that system. And the problems that we have in the system are not some metaphysical issue. It is our responsibility, right? We are all part of that. And so do your part to make it work, because it does work if we all do our part.
May I
Yeah,
add something
absolutely.
to that, please?
Absolutely.
If any of you get a jury summons, show up for court.
Amen.
And if you make it onto the jury, just remember, your voice is as important as everybody else. Don't let other people push you around because you're young or maybe they have a different status than you. Show up for your jury service. And if you make it onto a jury, remember that your voice and your vote belongs to you, and don't let anyone take it away from you.
Yes, and for me, I want to thank all the panelists. Dwight, I really appreciate you being here all the way from Lubbock, Texas. Zenobia and Grant, we appreciate you all three taking your time away from your families to educate our family of Houston and beyond. I want to thank Houston Community College Central and the SGA for allowing me to moderate this amazing, informative, dynamic, insightful, and knowledgeable panel of panelists. And a special thank you to Deborah, the SGA president, for being a listener of the LaRae Infinity Let's Talk podcast and hearing my special edition, Standing in the Moment, breaking down the system and bringing this to a bigger audience. I really do appreciate you, and I appreciate all of our audience for listening in. And I'm going to hand it back over to Deborah.
Hi, sorry for the change of scenery, have been up and down. I just want to thank everyone all of our panelists for participating, for being so informative and educating, not only Houston Community College Central, but all of HCC and especially all of Houston, even other parts of Texas. Thank you so much for taking time out of your very busy schedules to be here. And thank you so much for our moderator, LaGina Harris. We could not have this open and honest conversation without you. So thank you very much. And thank you to all my students and all the attendees that showed up to this to part 2 of our webinar series. We truly appreciate it. Stay tuned for part 3 of our webinar series that is on September 22 at 3 p.m. to 5 p.m. We are so excited. It is the Minority Experience in America, where we'll highlight the stories of what it is like to be a minority here in the United States. Again, thank you so much. Make sure to follow LaGina Harris. Her handles were just posted down in the chat. Check out the podcast. It is beyond extraordinary, and it's truly space that empowers everyone. And again, few dates to keep in mind is September the 30th. Make sure to fill out your census. The link was also posted on the chat box. October 5th is the last day to register to vote in Texas. And early voting goes from October 13th all the way to the 30th, and election day is November 3rd. These are very important dates to memorize, because we, like the panelists said, we have to vote and we have to stay informed and we have to educate others. And yes, definitely challenge two or three other of your friends to go out to vote and make them challenge other people, and just keep it going.
Absolutely. And a special thank you to our last week's Awareness Month panelist, Naeem. You did an amazing job talking to some community activists, and I appreciated that discussion.
Thank you so much, guys. And with that being said, thank you so much for tuning in. We'll see you on next week, Tuesday. Have a good day, guys.
Thank you.
Bye, everyone.
Bye-bye.